Hilchos Shevuos Perek Shvi, the Laws of Oaths, Chapter 7. We're beginning today to explore another category of oaths. In Chapter 1, the Rambam divided all oaths into 4 categories. Shevuos Bitoy, the standard oath, just about regular events, past or future. The Shevuos Shav, the useless oath, oaths that, to begin with, the moment they're uttered, are vain, for the different categories that I'm described in that. And the third category is Shevuos HaPikadon. Shevuos HaPikadon literally translates as the oath of deposit, but it really refers to an oath that concerns any type of money that you're holding that belongs to somebody else. As the Rambam said in Chapter 1, whether they gave you an object to watch or a loan, or you withheld wages, or somebody robbed someone else, and they're basically holding something which belongs to a fellow. There's 2 layers to the prohibition that this involves. Number 1 is if the person demands the money back and you deny owing the money, that in itself, the denial itself, is a prohibition. But then, if you go ahead and swear to the veracity of your claim, in other words, you're swearing to substantiate your denial, you transgress a further prohibition of making a Shevuos HaPikadon, of making a false oath with regard to deposit. And that's the subject we're going to be discussing today and tomorrow at length. As a point of introduction to what's coming, it would be good for us to study the difference between these 2 terms, Maimon and Knas. Maimon and Knas are 2 expressions to describe payments that have to be made halachically in different cases. The difference between them is that Maimon is restitutional payment. Payment that you're making to match the crime you committed. You damage someone's ox, you damage someone's property, you figure out the damages, and you pay for it. Knas is what's called in the Talmud a punitive fine. It means any time you're paying either more or less than what you actually damaged. The payment is not matching the crime. Either it's over and above the crime. Classic example would be when a thief has to pay back double of what he stole. If you're only making maimon, restitutional payment, you only have to pay back what you stole. The Torah imposes a fine, pay back double. That's knas. Sometimes you pay less than what your crime should actually require you to pay. That's also a knas. Classic example of this is what's called chatzi nezek. We're going to learn in the 10th book of the Rambam. There are some cases where when a person's property damages other property, you only have to pay half damages, not complete damages. That's a fine. That means the Torah is saying, in this case, we're going to impose upon you a fine you don't really deserve to pay because, let's say in the case of chatzi nezek, your property is not prone to damage, so really you should be completely exempt. The Torah is imposing a fine of half damages. So whenever Torah steps in and goes either above or below the crime, that's a knas. When it's restitutional, that's maimon. The reason that I'm introducing these 2 terms now is because as we're going to see, the whole prohibition of Shevuos HaPikadon revolves only around restitutional payment. In other words, any money which, had you agreed, not denied, had you agreed to be holding of a friend's, you would have to pay it back as is. That's where you're liable when you swear to the veracity of that claim in a case where it's false. But if the discussion is revolving around a type of money which is owed in the form of knas, a punitive fine, then swearing to the denial of it doesn't count for Shevuos HaPikadon. And it has to do with the terms the Torah uses, as the Rambam will define, but it's just important to know that going in. And now let's learn the Rambam himself. It says the Rambam Halacha Aleph HaTevei Chaveroi b'Maimon. A person demands, charges his fellow to give him money, she'im hoida ba yechayev l'shalem, that were he to admit to the truth of the claim, he would have to pay it. The kafar v'nishba, and instead he denies ever owing the money, and he swears to substantiate the denial. Or the person demanding adjured him. He didn't ask the guy to swear. He said, I'm putting you under oath that you owe me this money, and the man denied it. The person being charged, either on account of making the false oath or denying after being adjured, he's held liable for making a false Shevuos HaPikadon, a false oath of deposit. In this case, there's an exception, even though you didn't answer amen. In chapter 2, we learned that for a regular oath, if you want to be put under the power of an oath, you have to do some kind of form of verbal acceptance. Say amen, agree to it in some form. Here, you don't even have to answer amen. Shevuos hapikadon, because when it comes to the laws of the oath concerning deposits, echad hanishba mipi atzmai, ve'echad sheishbiya acher ve'kafar. It applies whether you swear on your own initiative or you're adjured by somebody else and simply respond with denial. Even if you didn't answer amen, you're liable. Because the response of denial after being charged, after being adjured with an oath, is basically like answering amen. You're acknowledging the oath, and you're saying, I still don't believe that I owe you the money. The denial in and of itself constitutes the acceptance of the oath. Halacha beis, tvoi b'mamin. If a person demanded money, she'im yoyda lo v'yoymar kein hadavar, lo yiyeh chayav l'shalem, that were he to admit and say, yes, it's true, I owe you this money, he actually counterintuitively would not be required to pay. Kegoin shetvoi b'knas, for example, the person charging him asks him for punitive fine money. Case I described to you before. Maimonides versus knas. And I should have probably said this in the introduction, but another core difference between restitutional payment and punitive fines is not only in their definition, whether they're matching the crime or not, but also there's a very special rule that says if you admit to owing knas money, you don't have to pay for it. It's kind of a funny law. Only if you're brought to court with witnesses who are charging you with a crime that owes a fine, then you have to pay the fine. But if you show up in court and admit to committing this crime, you don't have to pay the punitive fine. She'ein adam mishalim knas al piatzma. As the Rambam says, a person doesn't pay punitive fines on his own word. So if the person who's charging you is demanding that type of money, he's demanding a type of money that if you would respond with the truth and say, yes, it is true, I owe you that money, you actually wouldn't owe him the money, the kafar v'nishba, and instead of agreeing, he denies it flatly and swears to the denial, you're actually exempt on account of the oath of deposit. The chayav mishum shevuos bito. If it turns out that your oath is false, you're liable for taking a false oath of expression. But for the special oath of deposit, we're not going to hold you liable unless we're dealing with the specific category of maimon, restitutional payment. Another special law. If the charge was being made about real estate, or a slave, or a document, the kafar v'nishba, and in response the person denies and swears to his denial, pater mishvuos hapikadon, he's held exempt on account of the oath of deposit. The chayav b'shvuos bitoy shaharei nishba al sheker. You're liable for an oath of expression because in the end of the day you swore falsely, but you don't get held accountable for this special oath of deposit for the reasons we're about to say in the next halacha. V'lama niftar mishum shevuos hapikadon. Why are you held exempt on account of the oath of deposit? Seemingly, in the case of denying land, slaves, or documents, it goes into the category of maimon, restitutional payment. If you would have agreed to the claim, you would have to pay that which you're denying. Says the Rambam lefisha nemar, because it says in the verse concerning the deposit, what does it say? Bifikadain, oy v'sesum es yad, oy v'gazel, oy ashak esamisoy, oy matza aveda. Torah gives a bunch of examples. A person entrusted a deposit, a loan, a robbery object, a withheld wages. He may be found a lost object. Hakol mitaltelin. All the cases chosen by the Torah are cases of movable property. Sheim yoyde bohen, yoytzi mamay mitachas yadai. That if you're going to admit to them, all you're going to have to do is produce some kind of movable property, money, from your hands. This choice of words by the Torah, v'yatzu karkois, excludes land. She'ein mitaltelin, v'harein lefnei ba'aleinu b'chaskasan. They're not movable property, and therefore, in abstract halachic legalese, they're essentially always considered to be in front of their owner and in their presumptive ownership. Movable property can be moved around. I can hold it, you can hold it. Land can't be held by anyone. The proof is on the person who's sitting in the land to prove that he owns it. So when you demand the land from me, there's no case of me releasing something from within my authority, like I would take out a lost object or take out a withheld wage. Since the Torah only speaks about cases where I would have to produce something and give it off to you, that excludes land. That also automatically excludes slaves, where in the Torah are multiple times compared to real estate. They have the same laws. And it also excludes documents, because documents don't have any inherent value. They're only there to prove something else. They're an IOU note, let's say. But they themselves have no intrinsic value. And all the cases chosen in the Torah are things that have intrinsic value. Halacha hey, echad hanishba. The liability of swearing to a denial of a monetary claim applies whether you swear in response to a charge made to you by the plaintiff, or you swear on your own initiative without even a charge. Ketzah, what does that mean? Let's say a person is following a friend in the market. You can see he's about to ask him something. And the guy jumps and says, why are you following me? You think you have some kind of money in my hand? And I swear you have none of your money in my hand. The guy never said anything. He never charged him. He just comes out and swears on his own initiative. If it turns out that the oath is false, he's liable for swearing a false deposit oath. Since the bottom line is he denied it, he swore to his denial, even though he wasn't charged. Halacha vav, another rule. The law applies the same whether you swore to the plaintiff himself or to his attorney, some agent that he sent with his power. We have a principle in halacha: a person's agent is like himself in all respects. A person is not held liable for a deposit oath unless he is adjured in a language he understands. Guy can't speak to me Chinese, and then I say amen, and then I accept the oath. He has to be talking a language that I understand, and then when I respond in kind with a denial, then I'm held liable. If a person swears a false deposit oath purposely, even though he swore falsely, and there may have been witnesses warning him against his act during the moment of his oath, you don't get lashes. He only brings a guilt offering. The Rambam said this like in chapter 1. He's repeating it here in the context of exploring this oath. Because the Torah excluded this person who makes the deposit oath falsely from among the category of all those who are liable to lashes. Typically, for transgressing a negative prohibition, you get lashes. Torah here makes it clear that this person is excluded from that punishment, and instead obligates the person to bring a guilt offering, whether he does so purposely or inadvertently, as we explained in chapter 1. See there. Halacha tes, kafar v'nishba arba'y chamish pa'amim. If a person denied and swore to his denial, and he repeated the process 4 or 5 times, or the person, the plaintiff, was charging him multiple times, he was adjuring him 4 or 5 times, and he kept on denying each one. Bein bebezdin, bein shalei bebezdin, whether this exchange took place in court or out of court, sometimes it makes a difference. Here it makes no difference. For every false oath uttered, he has to bring a new guilt offering. And the reasoning for this law is, because for each individual charge, let's say he decided in the moment to do tshuva, and to reverse his denial and instead admit the claim, he would now have to pay and make restitution. Even though he established his denial in a court, if he would go back and admit it, he would have to pay. So that, in essence, every time he continues denying, he is continually exempting himself from payment. Therefore, he's liable again and again for each individual oath. If there was 5 people attacking him and telling him, give us the deposit which you have in your hands. In other words, we've entrusted something to you, give it back. And he responds, Shevuos she'ein lachem biyadi, in the plural form. If you appreciate the Hebrew nuance, lachem means in the plural. I swear to all of you that you have nothing in my hands. Since he made one all-encompassing oath, he's only liable once, for one sacrifice. But if he says, Shevuos she'ein lecha biyadi, le'lecha v'le'lecha v'le'lecha, he responds to each one individual, I swear I have nothing in your hand. I swear I have nothing of yours in my hand. I swear I have nothing of yours in my hand, or you. Chayav al kalachas va'achas, then he's liable again and again for each individual one, because he swore to each individual person. Halacha yud aleph amar lechaveira. If one friend tells you, Tainli pikadeh nesasumes yad, gezel va'aveda sheyesh li biyadcha. Return to me my deposit and my loan, the robbed object and the lost object. You have 4 of my objects in your property. Give me all 4 back. And the man responds, Shevuos she'ein lecha biyadi. One general tagline. I swear I have nothing of yours in my hand. You're only liable once, because you only said one oath. Even if he combined, had one coin worth, one pruta worth of them all together, they would combine and make him liable. But if he says, if he responds with specifics, I swear that you don't have in my hand a deposit or a loan or a robbed object or a lost object, you're liable for each one because you named each one specifically. A similar case. A person tells a friend, give me the wheat, the barley, and the spelt that you have from mine. I gave you my wheat, my barley, my spelt, return it. He responds, I swear I have nothing of yours in my hands. Only liable once. I swear I don't have wheat, and I don't have barley, and I don't have spelt. You're liable for each one. What if 5 people were demanding and saying, not just as we had before in halacha number 10, give us our deposit. They're saying, each one is saying multiple things. Return to us the deposit, the robbed object, the lost object, and the loan that we have in your hands. He responds to one of the 5. He names the specifics. I swear, you don't have in my hand a deposit, a robbed object, a lost object, or a loan. And then he repeats, not to you, not to you, not to you. Since in the first one, he said specifics, that translates to every individual addition. He'd be liable for each claim to each person, a separate offering. Which means he'd be liable, in this case, 20 guilt offerings, because each man made 4 claims. 4 times 5 is 20. Halacha tesvav, a person was confronted and said, give me back my deposit. And he claims, I lost the deposit. He denies ever having received the deposit. And he swore to substantiate his claim. Then he has a tshuva thought, and he admits to the truth. Actually, I still have it. I should give it back to you. But then he goes back and says, you know what, actually it got lost. And he swore to that claim. And then he agreed again, admitted again. So what you have to do is you have to pay back the principal and an additional 5th for every oath. The Rambam in chapter 1 told us that the punishment for swearing falsely for deposit is twofold. You have to bring an offering, plus you have to pay back whatever you denied to ever having with a 5th additionally to the principal. So before the Rambam was talking about offerings, now he's talking about the principal and the 5ths. Since you repeatedly made a denial about the initial principle, so you're going to have to make restitution of the extra 5th for each time. The principal you only pay back once, but the additional 5ths you pay back again and again. Shenemar, because it says in the Torah an unusual word, v'chamishi sov, and it's 5ths in the plural. Torah here includes that there could be a possibility of paying multiple 5ths for one principal. Keitzad, what would that look like? If the principal was 4 zuz, 4 coins, he denied, he swore, he admitted. He went back again and claimed that it got lost, and he swore to that and he admitted again. Then he says again it got lost, and he swore and he admitted. So three rounds. In total, he'll have to pay 7 coins. As I explained in chapter 1, when we say a 5th in Torah, we really mean a quarter, because it's a 5th of the total. So if the principal was 4, a 5th would be 1. You have to pay 1 for every additional oath. 3 times problematic oaths, that's 3. 4 plus 3 is 7. And the same thing would apply in all similar situations. A general rule. If a claim is being made about less than a pruta, it's a copper coin, it's not considered to be money, valuable money, significant money. Therefore, if a person is charged by a plaintiff that he owes him an object or money worth less than a pruta, the kafar v'nishban, he denies the claim and swears to the claim, pater mishvas apikadain, he's exempt from the deposit oath. Because the deposit oath only applies to a pruta. However, v'chayav b'shvas bitoy, he's still liable for swearing a regularly false oath, because the bottom line is you swore a false oath about a past experience. And therefore, for that account you'll be liable, but for the deposit oath you'll be exempt.